Hello people, welcome to the VirtuaLaw Academy. I am Pallavi Aggarwal and in this video we will talk about the Corporate Insolvency Resolution Process under the Insolvency and the Bankruptcy Code 2016. So to start it off, we begin to wonder that why is insolvency and bankruptcy a code and not an act? Because this code seeks to consolidate the existing framework that was there, having multiple laws, by creating a single law for insolvency and bankruptcy. Unlike the previous laws like the Sick Industries Companies Act 1985, there were cases that were pending for more than 20 years and there was no robust mechanism to revive a company if it had to see the fate of insolvency. IBC provides a time-bound process to resolve insolvency. Unlike the previous laws like the CIRP that used to shield the debtor company from creditor enforcement, instead of providing genuine rehabilitation and restructuring, IBC aims to shift the debtor in possession model that was prevalent to creditor in control model. So, in order to discuss this major aspect of the code, that is the CIRP, we have divided the process into 4 stages. First one being the default, second, the initiation of CIRP, third, the admission or rejection by the adjudicating authority of the application, and fourth, finally, is the CIRP that begins upon the admission of application by the adjudicating authority. So let's just get a brief about what are the 4 stages that we will discuss in detail in the later slides. So to begin with, first one is the default. Default is the trigger point for initiating an insolvency. Default is the point which leads a company to come under the Insolvency and Bankruptcy Code to see the fate of insolvency. So default is the main reason, default is the main trigger point that initiates or that may lead a company into insolvency. Second one, the initiation of CIRP. Who can actually initiate CIRP? How can he do so? And what are the conditions that are required that need to be fulfilled by the applicants in order to initiate CIRP? Third is when the application is filed by the people who are eligible to file the application, as discussed in the second stage. Then what is up to the adjudicating authority in order to decide whether it should admit or reject the application filed. Then if the adjudicating authority accepts the application, then the final process, that is the corporate insolvency resolution process, finally begins. So the stage 1 is the occurrence of default. As I said, occurrence of default is the trigger point for company to get into insolvency. So section 4 talks about the application of part 2 of the code to the corporate persons. It says that it applies when the minimum amount of default is at least ₹1 lakh. However, there is a provision given that states that the central government has the power to increase the minimum threshold to 1 crore, which has been recently done by the central government on the 23rd of March 2020. So, Section 4 talks about the application, whereas Section 6 states about the persons who may initiate CIRP. So, whenever there is a default by the corporate debtor, a financial creditor or an operational creditor, or the corporate debtor itself may initiate CIRP against the corporate debtor in the process, in the manner as is provided in the under the chapter. So let's begin with understanding them one by one. So we come to stage 2, that is initiation of CIRP. There are 3 persons who can initiate CIRP as we discussed, that is the financial creditor, the operational creditor, and the corporate applicant. It is only IBC that has classified creditor into financial creditor and operational creditor. In the Companies Act 2013, there was no classification of creditors as such, but IBC has done it for the first time. So let's see what IBC says about what is a financial creditor. So IBC defines financial creditor under section 5 subsection 7 of the code as to mean a person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred. In order to understand it better, we may understand that financial creditors are those people whose relationship with the corporate debtor is based on a financial contract, such as they must have given some loan or a debt security to the corporate debtor. Generally, the financial creditors are large financial institutions or banks. So, these financial creditors can file an application for or initiating CIRP against the corporate debtor under Section 7. So in their application, they will have to mandatorily propose the name of the interim resolution professional. They may file the application alone or jointly with some other financial creditor. These financial creditors will have to prove the existence of default by furnishing the record of default that may be available with the information utility or any other record or evidence that may prove the existence of default. So this was about the financial creditor. Now let's move on to operational creditor. So one may understand from the term itself operational creditors. So these are the creditors that have their credit due due to the normal operations of the business, due to the day-to-day operations of the business. IBC defines operational creditor under section 5 subsection 20 of the code to mean that any person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. As I said, we could easily assume from the name itself, operational creditor. These creditors are those whose liabilities from the entity comes from a transaction on operations of the business. So they may be the trade creditors or they may be your suppliers that have some due from the corporate debtor. Section 8 and Section 9 comprehensively talks about filing of the application by the operational creditor. So in addition to the requirements that is needed by the financial creditor to be fulfilled in order to file an application, operational creditor requires 3 more steps. That is, under section 8, it specifies that operational creditor will first have to deliver a demand notice to the corporate debtor demanding the payment of the unpaid operational debt. After delivering the demand notice, it will wait for 10 days for the corporate debtor to reply to such notice, either by proving that there was an existence of dispute and that is why the corporate debtor has not paid the amount, or else it will obviously pay the amount back to the operational creditor. So if nothing of these happens in the 10 days, in the 10-day period that is given to the corporate debtor, then the operational creditor can begin to file an application under section 9 of the code. Under section 9, it is suggested that the operational creditor may or may not propose the name of the interim resolution professional, but they shall furnish a copy of the invoice that demanded payment from the corporate debtor, an affidavit that there is no notice given by the corporate debtor as to the existence of a dispute, and like the financial creditor, they will also have to prove the existence of default, any record or any evidence that may prove that yes, there was an existence of a default. So this was about the operational creditor. Now moving on to corporate applicant or the corporate debtor itself. So the corporate applicant can file an application under section 10 of the IBC. It says that the corporate debtor shall, with its application, furnish a special resolution that would have been passed by the shareholders of the corporate debtor, or the resolution passed by 3/4 of the members of the corporate debtor in case it was a firm. So it needs to furnish a special resolution along with its application. It will also have to propose the name of the interim resolution professional, and like the other two, they will also have to prove the existence of default. So this was about the stage 2 initiation of CIRP by the 3 applicants that are eligible to file an application. Now let's move forward. To begin with the stage 3, that is the admission or rejection of the application by the adjudicating authority, we should first know what is the adjudicating authority under the Insolvency and Bankruptcy Code. It is the National Company Law Tribunal, that is the NCLT. So when an application is filed with the adjudicating authority, it should see its full completeness by looking at the 4 aspects that you can see on the screen. And there are various judgments, and it has been also included in the notes on clauses that an adjudicating authority should not go beyond these 4 aspects in order for it to admit the application. So if an application is complete in respect to these 4 aspects, it should admit the application and not reject it on any other ground. So let's see what are these 4 aspects that needs to be looked into by the adjudicating authority. So first one is the application should be complete in all respects. The sections have mentioned various documents and various requirements that needs to be fulfilled, that various documents that needs to be furnished by the applicant in its application. So the adjudicating authority should see that whether the application is complete in that respect, whether the form has been filed correctly. Now, the second aspect that needs to be checked by the adjudicating authority is that the existence of default has been supported by submitting an evidence by the applicant. So as we have discussed earlier, that the financial creditor or the operational creditor, or be it the corporate debtor itself, they will have to prove the existence of default, and in order to prove the existence of default, they may have submitted some evidence as to prove the default. So the adjudicating authority needs to check that there is a proper evidence which suggests yet to the occurrence of default. So now the third aspect that needs to be looked by the adjudicating authority is that whenever a financial creditor or the corporate debtor proposes the name of an interim resolution professional, as they have to compulsorily do it, and if the operational creditor also proposes the name of an interim resolution professional voluntarily, so they will have to check it with the Insolvency and Bankruptcy Board of India that there are no disciplinary proceedings which are pending against the proposed interim resolution professional. So these 3 aspects needs to be looked into an application by any of the 3 applicants. But the 4th aspect is additional for operational creditor if the application is filed by the operational creditor. So in its application, an operational creditor needs to submit an affidavit that states that there was non-existence of any dispute with the corporate debtor. So if the operational creditor has submitted that affidavit also, his application is complete, and if all these 4 aspects are there in his application, that then the adjudicating authority needs to admit it, and there cannot be any other ground on which it will reject the application. So after admitting the application, the 4th stage begins, that begins the fourth stage, that is the Corporate Insolvency Resolution Process, that is the CIRP. So, the day when the application is admitted by the adjudicating authority, that is the insolvency commencement date, the day zero of the corporate insolvency resolution process. So, along with the admission of the application, the adjudicating authority appoints the interim resolution professional, and also on the day zero itself, there will be a declaration of moratorium. What is moratorium? How is it taken into effect? We will discuss in our upcoming video. So till then, we know what happens on the day zero. The application gets admitted, the appointment of IRP is done, and a moratorium is declared on the assets of the corporate debtor. So now by the day 3, a public announcement is made in Form A, which invites claims from people who may have some debt due or some claims due from the corporate debtor. So the public announcement is done in an English newspaper and a vernacular language newspaper in order for people to know that they may submit their claims by the day 14 of the CIRP process. So the claims that can be submitted till day 14 of the CIRP, they can be submitted by the operational creditor, the workman, the employees, or financial creditor in the particular forms that are given for each of them to submit their claims. However, if they fail to submit their claims till the 14th day, they can still submit it till the 90th day from the insolvency commencement date if the reason for non-submission was condoned by the adjudicating authority. Now, by the day 21, the claims that were submitted will be verified. They will start be verified within 7 days from the last submission of the claim by the interim resolution professional. And after verification of claims, he will constitute a committee of creditors and he will report the constitution through the adjudicating authority. The committee of creditor comprises of financial creditors only, and it is up to the interim resolution professional to constitute the committee. Now, committee helps the interim resolution professional in taking the major decisions of the corporate debtor, in running the business of the corporate debtor, and what are its major functions or major duties that we will discuss later on. For now, we know that by date 23rd, a constitution of the committee of creditors should be done by the interim resolution professional. So day 30, till the date 30, the first meeting of the committee of creditors should be done. They will decide on a lot of matters, but primarily they will, and the most important one is basically they will decide that as to the appointment of resolution professional, whether they would want to continue with the existing interim resolution professional or replace him with another insolvency professional. So this is one of the decisions that they take in the first meeting only. So for rest of the decisions and what is the role of COC, what is a moratorium, and what all happens after the 30 days, we will discuss in some later video. Till then, thanks for watching.